Thank you, Don. It's really my privilege to be here because this is such an important issue. When you think about one issue that really strikes at the fabric of America, it's the abortion issue. It's the life issue, right? Even when you think about it as a lawyer, that is become the litmus test now for who's going to sit on the U.S. Supreme Court. And it continuously tears at the fabric of America. And so this is an incredibly important movement. This is an incredibly important issue, and I'm privileged to be here today. As Don mentioned, I'm co-founder and senior counsel of the American Freedom Law Center. We're a nonprofit, public interest law firm. I've been doing this type of litigation now for 14 years in state and trial appellate courts all across the country, defending the right to life. I formed the American Freedom Law Center with my colleague from New York, David Yerushalmi, who's an Orthodox Jew. And I'm the Catholic guy from Michigan with 12 kids. So we like to describe ourselves as the nation's first truly authentic Judeo-Christian law firm. And I think we can hold to that. And as I like to say with my 12 kids, all of them are boys except for 10. So you do the math, and you can see that the motto in my home, as I like to say, is "Blessed are you among women." You know, I served, and it was a privilege of mine to serve in the Marine Corps, serve our country in the Marine Corps for 13 years. My dad was in the Marines. My younger brother was a captain in the infantry in the Marines. My older brother was a sergeant in the infantry in the Marines. And, you know, I love this nation. I took an oath of office to support and defend the Constitution of the United States against all enemies, foreign and domestic. I was getting more concerned about our domestic enemies than I was about our foreign enemies. And so I decided to go to law school and get my law degree. I don't necessarily like to describe myself as a lawyer. I like to still describe myself as a Marine. I just happen to be a Marine with a law degree who's fighting these battles in the courtrooms. Because for good or ill, this battle for America's soul and even this battle for life is occurring in the courtrooms. Right? It was the Supreme Court that gave us Roe versus Wade. It wasn't through any democratic process. And so that's where this battleground is. And so I'm going to talk about personhood, and I caption it, if not now, when? Because I hear time and time again, now is not the time, now is not the time. You know, I want to, just an overview, this is what I tend to cover during my presentation is, you know, what should be our pro-life strategy, why a state personhood amendment, and why now? And let me just add this as a caveat. There's a Supreme Court case decided in 1986, Bowers versus Hardwick. In Bowers versus Hardwick, there was a challenge to the Georgia's sodomy laws. And this was advanced by the gay rights movement because they wanted to get into the law. They wanted to create this equal protection argument to protect sexual orientation and so forth. And the Supreme Court rejected it. And they lost. Did they give up? Of course not. Been fighting and fighting. In fact, and then in 2003, just a mere 17 years later, and here we are, how many years after Roe versus Wade? But 17 years versus later, they got that Supreme Court precedent overturned in Lawrence versus Texas, where they struck down the Texas sodomy laws. And that decision, Roe v. Wade, is obviously the most horrific decision from the Supreme Court, where it's sanctified as a constitutional right the killing of innocent human life. But Lawrence versus Texas is exceedingly dangerous. And the fundamental holding in Lawrence versus Texas is that morality is not a rational basis for passing laws. Think about how frightening that is. So, but is our cause less righteous than the cause of the gay rights movement, that they continue to press and fight to get what they want, how they want to shape the law? So we got to continue to fight this. What's our basic strategy principles? As Don said, in the personhood movement, it's no compromise, it's no exceptions. We need to defend the right to life at the earliest moments as well as at the later stages. One of my mentors, Professor Charles Rice at Notre Dame Law School, a champion of the pro-life movement. He's actually on our advisory board of the American Freedom Law Center. He talks about abortion as we understand it, but at the later end of life, he describes what's going on as postnatal abortion. And with government-mandated health care, we're seeing with the contraception mandate, we're seeing with these efforts to publicly fund abortion, and certainly with the end of life, where with these government deficits and with government-mandated health care and running up these huge deficits, I mean, it's really scary what's coming down the road here. And Sarah Palin got a lot of criticism for these so-called death panels. But at some point, there's going to be rationing of the health care, and It's really a frightening proposition. This slide here, you see, that's an actual ultrasound, 3D ultrasounds, and it's amazing. I even have some that are clearer than this, and I'm sure you've seen all the wonderful photographs you've seen of these young developing children. And the reason why I put this up here is I have of my 10 daughters, I have 2 that are married. My oldest one has 2 sons, so I have 2 grandchildren. The boys are coming towards the end. My second daughter, who was married in May, unfortunately, she lost her first child due to a miscarriage, and we had all the prayer warriors out there, and she gave us the good news last week that she's having twins. So this is actually my daughter's ultrasound. So I told her I was going to use it for a slide. And I told her, I told my kids, hey, you got to slow down the prayers a little bit, guys. We're next to, and one other, just a funny story, Professor Charles Rice, every time, he has 10 children. He was a terrific example to us. We're in law school about promoting life. And every time when I tell him, I say, oh, Professor Rice, my wife is expecting again, or even I told my daughter, he'd always say, oh, they're having twins. And so when I contact him and tell him, hey, Professor Rice, my daughter Sarah is actually having twins, so you're going to be right this first time. Then he paused and he goes, I think she's having triplets. I think I see someone hiding behind that big guy on the right. So, but he's a real champion of the pro-life movement. You know what? How do we define victory? I mean, that's one of the things that I think we lose sight of. Where's victory? And I always point to what St. John Paul II said in Evangelium Vitae, the Gospel of Life. The human being is to be respected and treated as a person from the moment of conception, and therefore from that same moment his rights as a person must be recognized, among which in the first place is the inviolable right of every innocent human being to life. That's personhood. That is fundamental Catholic teaching. That is what personhood is about. That's how we should define victory. It's very interesting. In a Supreme Court case, Justice Brennan, of all people, hardcore liberal who's very pro-abortion, he said the right to life is the paramount right because death forecloses all other rights. Now, he certainly didn't say that in an abortion context. He said that in the capital punishment context, but that's certainly the point. Death forecloses all rights. And this is how we need to define victory, right? And why a state personhood amendment? After 41 years of abortion on demand, it's time to rethink our pro-life strategy, to include efforts to end abortion, to protect innocent human life. Nearly 90% of all abortions occur during this first 12 weeks of pregnancy. This is the key terrain. And there's, why a state personhood amendment? I think there's really, 4 fundamental reasons. You could probably come up with others, or they could probably fit within these. First and foremost, it's the right thing to do. We know it. I mean, we know as Americans that this issue is not going to go away until we defend human life. Right after the Supreme Court declared from on high, right, the Supreme Court is sort of the secular magisterium, right? As even one Supreme Court justice said, we're not final because we're infallible. We're infallible because we're final. And for them to proclaim this abortion right as a constitutional right, it takes on a sort of secular morality. But we know, even though they decided this decision, 40 some odd years ago, it's still tearing at the fabric of America, because we know we have a collective conscience as Americans that this is wrong. As I said, this has corrupted our entire political process. You can't become a Supreme Court justice, a nominee from the Democrat Party, certainly. We know the Republicans have given up. We've had plenty of opportunities to put pro-life justices on the Supreme Court, and we failed miserably. But the Democrats always seem to hit it 100% of the time. They always seem to find the right justice who's going to secure this, the right to abortion no matter what. But it's corrupting our political process. And I laugh. It's funny. I gave an argument in federal court just Thursday in Buffalo, New York, defending a Christian teacher. And there was a law school class that came to watch the arguments, and I got to address them afterwards and try to give them a little bit of reality of what the law really is. This notion that justice is blind is ridiculous, right? And even Ruth Bader Ginsburg, I don't know if you saw the interview she gave recently, where she said she's not ready to retire yet because Harry Reid hasn't invoked the nuclear option for Supreme Court justice appointments, as he did for the lower courts, and she's not certain that they're going to get somebody on the Supreme Court who has the right perspective and personality and so forth. What is that all about? I mean, aren't you supposed to be, blind to what the law is and declare what the law is? No, this is politics. This is hard politics even at the Supreme Court. But it's the right thing to do, and we know it. And you're sitting here today, I know, because you know it. You know in your conscience, and America's collective conscience knows that we need to defend life. Right? It's our founding principle. It's that inalienable right to life. The second principal reason is the elephant in the room is Roe versus Wade. As much as we want to take an incremental approach, I hear this all the time, that's fine. I mean, we should have legislation that tries to reduce the number of abortions, that protects life at every end of the spectrum, but we can't give up on a strategy that has as its main goal to protect human life, period, no exceptions. And the elephant in the room is Roe versus Wade. Until we can get rid of Roe versus Wade, we're going to continue just to be chipping at the margins. And in my view, the best way to have a legal challenge to go after Roe versus Wade is to pass a state constitutional amendment. Why? Because the constitutional amendment goes after the essential, central holding of Roe versus Wade, and that being that an unborn is not a person under the law who can receive the protections that the Constitution should be provided. So it goes right at that central core holding of Roe versus Wade. The other reason is, if you just pass legislation, the problem you're going to run up against is that many states have now incorporated into their state constitutions an abortion right. NARAL, Planned Parenthood, these guys, they're not sleeping at the switch. They're working very hard because they know, every law professor really, any honest one who's ever written about Roe v. Wade, writes about what a horrible decision it is. There really was no precedent, no basis for it. I mean, this thing is on very, very thin ground, and they realize it. And so does the abortion rights advocates. And so they're going around states to state and ensuring that they have a state abortion right as a matter of state constitutional law. So if Roe v. Wade eventually does fall and it gets turned back to the states, then they can always turn to their state constitution as a way of protecting their right to abortion. The problem with the states that do have these state abortion rights, if you pass legislation that wants to restrict abortion some way, it's not going to be challenged under Roe versus Wade, it's going to be challenged as a matter of state law. So if you have a state constitutional amendment, you do multiple things. Number one is you take out of the mix the whole state court addressing this issue, because there's no state, the state constitution trumps is the supreme law in all the states. So if you have just a statute that's passed, it could get struck down in a state that has a due process right to reproductive choice, like New York, for example. They could strike it down on the state law side, or you could end up having a state that doesn't have the state abortion right. And now all of a sudden you've got these liberal judges on the bench who, out of this case, decide, well, you know what? We do have a right to privacy under our state constitution, and so they end up creating it. So you remove from the entire calculus the whole state law issue, and the only way you can challenge a state constitutional amendment substantively is through the federal constitution, and that's Roe versus Wade. So this goes right to the heart of going after the central holding of Roe versus Wade. And it establishes as a matter of state constitutional law that is a right to life state. And if you look at it from the perspective of a Supreme Court justice, when a case comes up to them, what a compelling case to make that, you know what, there's no right to abortion in the federal Constitution. And quite frankly, even the judges, if you count the justices, you got Alito, Roberts, Scalia, and Thomas, who hopefully are in our camp, Alito and Thomas, but they're not going to, they're of the nature, they're strict constructions. Their legal philosophy is not that they're going to take up a case like this and then find a right to life in the Constitution. That's not the way. They're likely to say, you know what, Roe versus Wade was wrongly decided. There isn't this right to privacy and the penumbras from the emanations of the Bill of Rights. That's literally the language. Every first-year law student is looking up penumbras. What's in a penumbra, in the dictionary? So they had to make this right up out of whole cloth. It's going to go back to the states. That's where the battleground is going to be. Even if we get Roe versus Wade reversed, it's going to go back to the states, and now we have the states affirming that it's a state constitutional right. And also, when you have a state that has declared that this is our fundamental principle as a state, a constitutional principle, that's going to get the attention of the Supreme Court. So I think if you're going to challenge Roe versus Wade, In my view, the best legal strategy is to get a state constitutional amendment passed, it inevitably be challenged, and then bring it up to the Supreme Court. The other, and this third point might even be moved up to number one, or probably number two, because it still is the right thing to do. Education. You can't be dismissive of the educational opportunity this brings to everybody. How do you change public opinion? Or I should start it this way. How do you change public policy? You change public policy by changing public opinion. And how do you change public opinion? You have to have public discourse on the issue. You know, one of the things, to me, one of the best benefits of the whole litigation on partial birth abortion was the educational component of it. Right? All the right to life, national right to life attorneys and everybody's were naysaying, said, "Oh, this is never going to pass. This is going to set us back." And you know, we ended up winning in the Gonzalez versus Carhart case, and they upheld it facially, which was I'm going to talk about that case here momentarily. But if we could use the partial birth abortion legislation to educate the American public about the horrors of late-term abortion, use the Personhood Amendment arguments to show the American public the horrors of early-term abortions. It's the destruction of human life, period. And there is a huge educational opportunity that we can use. Because when these things make it on the ballots, they make the news. It gives people to get out there and to talk about the issues and keep this issue alive and to focus it at the right end of the spectrum, on the early end of the spectrum, and focus it on the perspective that all human life is worthy of protection. And certainly, we need to restore the culture of life. Because again, most of this is always in the context of abortion, but I know we're going to have speakers today talking about this, the horrific things that are happening at the other end of the spectrum of human life, where we're reaching the point where we're making this sort of public policy determination of which lives are worthy of living, right? And that's almost a title of the treatise that was the basis for what happened in 1939 and the 40s in Nazi Germany. And it's a scary road to be going down. You know, we hear criticisms, and I hear them all the time, and I've been, just speaking on this issue for many years now. You know, Martin Luther King, and I think he nailed it, and he was obviously talking about the civil rights movement, but this is the greatest of civil rights movement, right? I'm sure I'm representing actually his niece, Alveda King, and she's one of the plaintiffs in the Priest for Life lawsuit challenging the HHS contraception mandate, which really is an abortion mandate because it covers abortifacients. You know, wait almost always means never. And so I would ask, if we're not going to do it now, then when? And again, even for the educational component, we got to keep fighting, keep knocking on that door, keep pounding this issue in the public discourse. And certainly there's political realities of what, which states may have some success. And I know there's going to be, again, speakers talking about this later today about where they are on some of these cases. And some of these, there's a very good chance of prevailing. But you're not going to prevail if we don't try. I want to talk about the Supreme Court, because by most accounts, I should say, the swing vote on this issue is going to be Justice Kennedy. And just by way, a little bit of background of Justice Kennedy. Justice Kennedy's I'm afraid to say he's actually a Catholic. He doesn't rule in that fashion whatsoever. But I do think that people can be moved. And I do think that people have functioning consciences. And I do think that a lot of prayer lifted up for Justice Kennedy to have a revelation here in the later years of his life of what a mistake he made in 1992 in the Planned Parenthood versus Casey. Planned Parenthood versus Casey in 1992 was a real chance at reversing Roe versus Wade. I mean, it literally came down to the 11th hour, and by all accounts, Justice Kennedy changed his vote to vote in favor of retaining and affirming the central holding of Roe at the 11th hour in that case. And I think, when I look at his dissent in the Carhart case, which was the first, the Carhart versus Nebraska case, the first partial birth abortion case, and then the Gonzalez case, which I'm going to talk later, these justices, they're human beings. They see and that's why it's so important to do the March for Life. They see what's going on outside their windows, at the March for Life every year. How many, thousands, hundreds of thousands of people coming out. And I'm not going to give up hope on this panel. I think if there's any time that we need to take a shot at getting Roe versus Wade reversed, it's now. I really do. I think it's now. I think Justice Kennedy, in my view, based on what he has written in other cases, is likely regretting his 11th hour change. I think he's somebody that could be convinced to say, you know what, turn this over to the states. Get it out of the Supreme Court. The first thing we have to do is get it out of the Supreme Court, get it returned to the states, which then goes right back to this effort to get these state constitutional amendments. And I think there's a chance that could happen, and I can tell you miracles do happen. They really do, and I know everybody in here believes that, and we are. I really think that we're relatively close to being able to get this moving. Here's what Kennedy wrote, and remember in Planned Parenthood versus Casey, he was the swing vote that upheld the central holding in Roe. In the Nebraska partial birth abortion ban, which the Supreme Court struck down, Kennedy wrote a scathing dissent. And the essence of his dissent was essentially, I've been duped. I was duped as a justice by my colleagues to think that Planned Parenthood versus Casey, by moving away from this super abortion right in Roe to create this substantial burden test of Casey, that we were going to be able to allow states to have a stronger say now in restricting the abortions that are going to take place. Well, that hasn't happened. I mean, we still have abortion on demand right up until the very last moment. And he wrote a scathing dissent in the Carhart case, and then when the partial birth abortion ban came back up again in the Gonzales, he actually wrote the opinion. And here's some very interesting things I want to highlight on this opinion, why I have a measure of hope that we could get a case up to the Supreme Court. But again, the Supreme Court just doesn't wake up one morning and say, you know what, we're going to redecide this Roe versus Wade case. They only can decide cases or controversies. Unless they have a case on all fours before them that's going to directly challenge the central holding of Roe, Roe is going to be there forever. So until we make efforts like this Personhood Amendment, state by state by state, and get a case that's going to get up there, Roe's going to stay where it is. Justice Kennedy, he starts off by saying, we assume the following principles for purposes of this opinion. And his assumption was on the principles established in Casey, the central holding. Here's Justice Ginsburg's dissent, and I apologize for the busy slide. I'm going to go through it. It allows me to not have to worry about notes when I'm up here talking. But this is what Justice Ginsburg said in her dissent. The court's hostility to the right Roe and Casey secured is not concealed. Throughout, the opinion refers to obstetrician gynecologists and surgeons who perform abortions not by the titles of their medical specialties, but by the pejorative label abortion doctor. She's referring to Justice Kennedy's opinion. A fetus is described as an unborn child and as a baby. Second trimester pre-viability abortions are referred to as late term. And the reasoned medical judgment of highly trained doctors are dismissed as preferences, motivated by mere conveniences. This is Ginsburg pointing to what Justice Kennedy wrote, sending a shiver up her spine and certainly up the spine of NARAL and Planned Parenthood and everybody else. And she goes on. And most troubling, Casey's principles confirming the continuing vitality of the essential holding of Roe are merely assumed for the moment rather than retained or reaffirmed. Though today's opinion does not go so far as to discard Roe or Casey, the court, differently composed than it was when we last considered a restrictive abortion regulation, is heartily faithful to our earlier invocation of the rule of law and the principles of stare decisis. I have to pause here. You almost want to laugh when you hear people like Ginsburg talking about stare decisis and rule of law, where they create this abortion right out of whole cloth. But that's what she is sending out the alarms to all the pro-aborts out there that, hey folks, we've got a court now that I am seriously concerned about the holdings of Roe and Casey. She's concerned, but yet what's the pro-life movement doing to capitalize on this moment? We need to push the Personhood Amendment to get a case before this court. Try it. The other criticism that I often hear is that, well, you know what, if we bring a case out of the Supreme Court now, a super abortion right is going to be created on the Equal Protection Clause, because Justice Ginsburg at one point had written something in a Law Review article thinking that, you know what, Roe was, if they should have decided Roe on the equal protection grounds rather than creating this right to privacy under due process. But we go from where she, I just went through what her dissent was. The court's not going to create a super abortion right under equal protection. Guess what, folks? We have a super abortion right under the Due Process Clause. People, and I'm just going to run through these. I want to save time for some questions here at the end. People talk about, well, if we have this, if Roe gets reversed, it's going to repeal all of these abortion restrictions by implications. It's not. I mean, these are scare tactics. The other thing that I often hear is, well, I don't support a state amendment, I support a federal constitutional amendment. Terrific. I'd love to have a federal constitutional amendment. As I understand, I think the national right to life, one of their reasons for finding was to have a national, a federal constitutional amendment. The problem is that is very, very difficult to do, and the political realities are such that it's not likely. That's not the same that we have in various states, as again, I know other speakers will be talking about the successes they've had. And I always love this one. You were disregarding the mother. My wife, we've had 12 children. And I can tell you, she was never disregarded during any of these pregnancies. And the doctor knew full well that when she was coming in with that child, that the doctor had 2 patients. That's what we need to understand. We have 2 patients that both are taken care of, and both whose lives should be respected and protected. The left likes to call this a war on women. And I know everybody in here realizes, what's the true war on women? It's abortion, it's pornography, it's everything that the left supports as some fundamental right. And we don't need enabling legislation. That's another thing I always hear all the time. If Roe v. Wade gets reversed, Roe v. Wade has been the barrier and the obstacle to enforcing existing civil and criminal laws in ways that would restrict the killing of innocent human life. You remove Roe v. Wade, you remove that obstacle. But these, again, are the naysayers that I hear all the time. One other thing on the partial birth abortion, and another thing that I think is really, really important about personhood. If you support personhood, there's no question you're right to life. There's no question that you understand that the unborn need to be protected from the earliest moments of life. The partial birth abortion bans, to me, one of the greatest negative effects was it provided cover. Provided cover for politicians. Because it's very easy at the cocktail parties to say, well, I oppose partial birth abortion. And unfortunately, I think the more the pro-life movement had become mainstream, the more it lost its true focus. Because it became easier now to discuss at these cocktail parties in Washington, D.C. about being pro-life, and I support the ban on partial birth abortion, right? I think Senator Moynihan, supported the partial birth abortion ban. Personhood. You ask your politician, do you support a personhood amendment? You'll know right away whether that politician is pro-life or not pro-life. So it's important that we have very clear discourse in this public policy discussion and public policy debate, and this does it. So I want to wrap up here. Planned Parenthood, NARAL, ACLU, just what Ginsburg said, they fear what we are afraid to do as a movement. And I say we, I mean certainly there's plenty of people here that are doing this, but we need to bring on board the entire pro-life movement, the entire national pro-life movement. And I really think the youth are becoming more and more pro-life, and they realize the lies that have been sold to them by their elder generation. And then look at that. What will the next generation say about our unwillingness to test this court with a direct challenge to Roe versus Wade? I think the time is right. The time is now. And it's always the right time to do the right thing. And this last quote, I think, is from the famous sports philosopher Wayne Gretzky. You miss 100% of the shots that you don't take. This is an imperative. This is something that we need to do now. Now is the time. Now is the time to press these personhood amendments in every state. Thank you.
Rob, one of your slides said that there is a fear out there about establishing a super right for abortion. Now, we have found that the most persuasive argument against the personhood effort. I mean, is not the fetal pain ban, couldn't the court reach down and grab any court case?
They could.
To establish a super right?
They absolutely could. They could do that with any case. They could do it with the funding cases, because that's actually where they're making the claim that there should be this broad equal protection is under the funding cases, and the courts have rejected it. And the states, most of the states have rejected that as well. There's so many, this super abortion right nonsense from the Equal Protection Clause. Again, it's a scare tactic, and as Dan mentioned, I hear it all the time. That this now we're going to have the Equal Protection Clause is going to protect abortion, and so it's going to then now apply to the funding cases. It's now going to apply to these to these other restrictions that we have. That's just nonsense. I mean, we're at the cusp right now of where you saw Ginsburg's dissent, where a majority of the court is ready to discard Roe versus Casey. But all of a sudden, they're going to be willing to discard Roe versus Casey, but they're going to create something even more powerful than Roe versus Wade. I mean, it just doesn't even make any logical sense, and I can tell you it doesn't make any sense from a legal perspective either. Yes, sir.
Yeah, just in the last couple of years, we've seen how the push to redefine marriage. I'm purposely not saying the word same-sex marriage, but how a lot of it is involving the courts, circuit courts, striking down state constitutional amendments, defining marriage as it should be, and they're not even getting to the Supreme Court. So if we pass state personhood amendments, what's to keep just even before it gets to the Supreme Court, the circuit court saying, oh, this is in violation of Roe v. Wade, scratch it out.
Yeah, I mean, that's you have to go through the process to get to the Supreme Court. There's no question about it. And the Supreme Court hasn't, and I think the Supreme Court hasn't taken it up because there's been enough justices that don't want to go even further than where it has gone. It has gone now. That's the necessary evil that we have to deal with. But the point is, if we don't do that, if you don't have an appellate court decision that's saying Roe versus Wade strikes down this state constitutional amendment, guess what? You're never going to have a cert petition to the U.S. Supreme Court. You can't get there from here. I mean, it's likely going to happen. Who knows? You might even have a circuit court that upholds it. But they'd have to find some way to work around Roe. I would just as soon have challenge it, get it struck down the district court, Roe versus Wade. Struck down the circuit court, Roe versus Wade. Hey, Supreme Court, take this up. You got to fix this mess that you created in 1973. The very mess that, oh, by the way, is affecting every future judicial appointment, particularly on the Supreme Court. It has corrupted our entire judicial system. There's so many arguments to make, even from a policy perspective, that in my view, could interest this court in taking it up. But you're right. Are they going to strike it down? Yeah, I would expect them to, but we can't get to the Supreme Court until we've taken that step. Yes, Becca.
Well, don't you think that this is so different because Roe v. Wade only applied to pregnant women, and personhood also applies to embryos. And so it's not like the whole statute, the whole amendment could be struck down, because with embryos you're not talking about a woman's body.
Okay, there's a basic principle that the courts apply when they're reviewing the constitutionality of a statute is they rule on the narrowest grounds they could. You could still have some segment of the personhood amendment applying, such as the end of life issues, such as dealing with are they going to discard these embryos and in vitro fertilization. So you could even have those gains. I want to go for the golden ring, though. I want to go for Roe versus Wade. But certainly you could have the amendment saying that that you could have a court saying it strike it down in terms of its application to Roe versus Wade, but apply it in another context, which again just allows us to continue to build the culture of life around with the exception carved out for the Roe versus Wade. But again, I want to go after the heart of it. But you could possibly have portions of the amendment upheld as applying to other aspects of the culture of life. Yes, ma'am.
Have any of the states been successful in advancing or accomplishing personhood?
Yeah, and there's other speakers after me have the actual details on that. I know I think it was North Dakota, and I don't want to. I'm afraid of stealing anybody's thunder, so I'll leave that to them addressing the I don't get involved in sort of the grassroots ground political thing. I stay at the kind of at the legal level on these things. But it takes the grassroots to do this, right? It takes people talking about it, discussing it, and to get this. And if we can, and he brought up the issue of the same-sex marriage. I mean, just 10 years ago, virtually every state's constitutional amendment passed. I mean, they passed almost overwhelmingly. And look where we are today. The other side is very effective at changing the public discourse. And that's what got these courts. Trust me, the judges are not. They're still humans. Where's the public opinion on this thing? And that's why I think you're starting to see these things coming down. Is that there's been a change in public discourse, and so we're having essentially a change in public policy, and it's also affecting the judges. Which, by the way, I think is just absolutely ridiculous. Michigan, for example, they struck down the Michigan marriage amendment. You had a federal judge in Michigan, not to go off on a tangent, but this drives me crazy, who had listened to testimony of social scientists, to weigh the different social scientists to see whether or not Michigan had a rational basis to declare that marriage was between one man and one woman. A rational basis, the lowest level of law. I'll give you a rational basis. My response to this would be, one word: biology. But he still struck it down. Hopefully the Sixth Circuit will reverse it. I think they're going to. But yes, sir.
What's the weakness in the argument that, as our laws and local laws state, that a woman actually does not have the right to her own body? She doesn't have the right to slit her wrist. And yet we give her the right to slit the throat and cut the limbs and arms off a little baby or a fetus, whatever you want to call it. And so what's the weakness in going for that angle of argument?
Weakness in arguing that, look, you don't have
a...
you
does
don't
not
have
the right to her body. She doesn't have the right to harm or destroy her body in life-threatening ways, and yet we give her that right for another body within her. She can't do that to her own body, yet she's doing it to another body.
Well, I mean, I'll even go further. That there's some states that you have a pregnant woman walking across the street, literally getting an abortion, but before she gets there, she gets run down by a truck, and both the unborn child and the mom is killed, and now you have 2 counts of homicide. Yeah, the law. I mean, it doesn't make any sense. People ask me, like, with these personhood amendments, if they had criminal laws. Well, what is the criminal penalty that you're going to impose upon a woman? I mean, that's one of the questions that often come up, and how I typically I turn that back to them by asking them a question. I say, so if a mother delivers the child and throws the baby in the dumpster, what should the criminal penalties be? Let the legislature decide. Have a public debate and discussion on that. How is that any different? Maybe there's no criminal penalty. I mean, maybe the penalties are upon a doctor who's going to intentionally do this. I mean, but that's, the legislature, we need to have discussion and debate on this, but how is that any different? Yeah.
One state, the state of Alabama, has found at the state Supreme Court level just recently that a child is a person from its earliest biological beginning, except for the case of abortion because of Roe v. Wade.
Yeah.
Chemical endangerment, the child is a child. The state has a protected interest in that child.
Right. And the concept of personhood, because obviously Roe uses that, but one of the issues, like with the Hobby Lobby case, one of the issues they had to decide is whether or not a corporation was a person for purposes of the Religious Freedom Restoration Act. We create this legal fiction where corporations are persons under the law, but yet we exclude a human being as being a person. Remember the last time we did that, right? Dred Scott and so forth, and how did that turn out? All right, thank you. Appreciate your attention.